Today's case is one of those lawsuits that sounds very impressive when it's printed on expensive paper and carried into court by people billing $900 an hour. Humanity keeps inventing creative ways to waste everybody's morning. A billionaire CEO's daughter is suing her former assistant for leaking confidential company documents. But before this case is over, this courtroom is going to find out whether the real crime was betrayal or what those documents revealed about the company desperate to keep them buried. That morning, Nneka Adeyemi was awake at 5:47 a.m., not because of an alarm, because that is simply when her body wakes up now, conditioned by 4 years of early start times, of being the first one in and the last one out, of a life built entirely around being ready before anyone asked her to be. She ironed her blouse in the kitchen because her apartment is a studio and she doesn't own an ironing board. She ate half a piece of toast because she wasn't hungry and probably wouldn't be. She took the 6:15 bus because the 6:45 sometimes runs late, and she has never in her professional life arrived anywhere late. Not once, not in 11 years of working. She arrived at my courtroom at 8:32 a.m. She sat in the hallway on a wooden bench with her documents in a manila folder, not a briefcase, a folder, the kind you can buy for 40 cents at a drugstore, organized into sections with posted tabs. She had color-coded herself. She had no attorney. She'd spoken to 3, and each one had told her the same thing in slightly different language. The case was strong, but the opposition was stronger, meaning they had more money than she had, meaning it would cost more to fight than she stood to win. So she sat on that bench alone. At 9:04 a.m., a black car, not a taxi, a car service with tinted windows pulled up to the courthouse steps. Celeste Hargrove did not check whether her parking was legal. That's what the driver is for. She was on the phone as she walked in. She ended the call somewhere around the metal detector, not because of the security protocols, but because the conversation was finished. She was wearing a jacket that costs more than Nneka makes in a month. I noticed it immediately. I've been on this bench for over 40 years. In that time, I have seen every variety of human being walk through that door. I have seen the terrified and the arrogant, the innocent and the guilty, the people who enter this room with fear in their eyes, and the people who enter it with the absolute conviction that fear is something that happens to other people. Celeste Hargrove walked in like the courtroom was a room in a building she already owned. She glanced at Nneka once when she sat down, not at her face, at her folder. There was a flicker at the corner of her mouth that I have no interest in describing as a smile. Her attorney, a senior partner at a firm I recognized, a man named Patrick Holloway, who had appeared in my courtroom twice before and both times known better than to waste my time, leaned over and said something quietly in her ear. She nodded without looking at him. I said, "Miss Hargrove, we're going to begin." She looked up from her phone and said, "Of course, absolutely," in a tone that suggested she was granting me permission. We were going to have a very interesting morning. Let me tell you about Nneka Adeyemi. She is 34 years old. She came to this country at 19 with a scholarship, a suitcase, and a plan that she has, by any reasonable measure, executed with extraordinary precision. Business degree, top of her class. Entry-level position at Hargrove Technologies at 23. Personal assistant to Celeste Hargrove's father, Warren Hargrove, CEO and founder within 2 years. She made $54,000 a year. For 4 years, in one of the most expensive cities in this country, she made $54,000 a year working for a company that reported $2.3 billion in annual revenue. She took her lunch at her desk. She answered emails on weekends. She did not complain about any of this. because she understood that she was building something, that patience and excellence were the currency she had, and she was spending them carefully. 14 months before anything became public, Nneka Adeyemi noticed something. She was processing payroll documentation, not her job, but someone had asked her to cross-reference a spreadsheet, as they often did, because she was precise and reliable, and she saw a number that didn't match, a salary figure. A woman in the engineering department, 11 years of experience, rated exceeds expectations in every review for the last 6 years, paid $18,000 less per year than 3 male colleagues with equivalent ratings and fewer years in the role. She told herself it was a formatting error. She checked another name, then another. She sat very still at her desk for approximately 20 minutes. Then she opened her company's internal HR compliance portal and filed a report, formal, documented, with the spreadsheet attached. 3 weeks later, she received an automated response telling her the report had been received and was under review. It stayed under review for 4 months. She filed a second report. This one she sent directly to the head of HR with a cover email explaining specifically what she had found, including a summary of 11 employee records she had by then reviewed. She was polite. She was precise. She used the word concern 6 times, so nobody could accuse her of being inflammatory. She received a response in 11 days telling her that the company's compensation structure was compliant with all applicable regulations and that any perceived discrepancies were the result of performance-band classifications that required specialized context to interpret correctly. In other words, you don't understand what you're looking at. She understood exactly what she was looking at. She waited 3 months. She watched nothing change. She filed a third report, this time to the company's external compliance hotline, a number that, per their own published ethics policy, was monitored by an independent board member. She never received a response. 6 months after that, she was called into an HR meeting and told that her position was being restructured. Her role had been consolidated. There was a severance offer. 6 weeks of pay in exchange for a signed non-disclosure agreement stating she had no claims against the company and would not discuss her employment publicly. She did not sign it. 2 weeks later, she gave one document, 1 page, the payroll summary for the engineering department, to a journalist she had found through a mutual contact, a journalist with a reputation for accuracy. She gave it to him with a single sentence. I tried to fix this from inside for 14 months. I have nothing left to try. The article ran on a Thursday. By Friday, she had received a letter from Patrick Holloway's firm informing her she was being sued for breach of confidentiality. She put the letter in her manila folder. She took the 6:15 bus to my courtroom, and she sat on that wooden bench with her 40-cent folder and her color-coded Post-it tabs. And she waited. Patrick Holloway opened the case with admirable efficiency. He was, I will say, doing exactly what he was paid to do. The argument was clean. Nneka Adeyemi had signed a confidentiality agreement upon hire. The document she shared contained proprietary internal data. Sharing it constituted a clear breach. The plaintiff sought $85,000 in damages, a number chosen, I noticed, that was just above the threshold for small claims and just below the threshold that would have drawn significantly more scrutiny. He sat down. Nneka stood up. She was calm in a way that I have learned to recognize. Not the calm of someone who isn't afraid. The calm of someone who has already accepted the worst and found, to their own mild surprise, that they can survive it. She said, I reported a problem through every channel the company provided. 3 times over 14 months. No one acted. I made one choice that I understood would cost me, and I made it because 340 women were being underpaid, and I was the only person in a position to change that. I'm not here to win anything. I'm here because I won't sign something that says I was wrong. She sat back down. The courtroom was quiet, not the quiet of uncertainty, the quiet of a room that has just heard something true. The reporter in the 4th row covering this as a routine procedural follow-up to the original article had stopped typing. An older woman near the back, waiting for her own case, had her hands folded in her lap and was looking at Neko with an expression I recognized from my own mother's face, something between grief and admiration. Patrick Holloway was looking at his notepad. I said, "Mr. Holloway, we're going to proceed with questions." I began with Celeste. "Ms. Hargrove, you're the plaintiff in this action?" "That's correct." "And you personally authorized this lawsuit?" A slight pause. "My legal team and I made that decision together?" "Yes." "Your father's company, your legal team." I let that sit for a moment. "Are you an officer of Hargrove Technologies?" "I serve on the advisory board." "Advisory, not board of directors." "That's correct." "So you have no fiduciary authority over company decisions." Patrick Holloway said very quietly, "Your Honor, I'm asking a factual question, Mr. Holloway. Ms. Hargrove, I have significant influence over—" "That's not what I asked. Fiduciary authority, yes or no?" A pause. "No." "Thank you. Ms. Hargrove, you've stated that Ms. Adeyemi violated a confidentiality agreement. How did you become aware of what information she had shared?" "From the article, when it was published." "From the article, not from an internal investigation, not from HR, from reading it." "Yes." "So you did not have prior knowledge that Ms. Adeyemi had concerns about compensation practices at your father's company?" She hesitated for the first time. "A small thing, the kind of thing most people in the gallery wouldn't catch." I caught it. "I was aware there had been some kind of internal complaint." Some kind of internal complaint. I repeated that phrase the exact way she had said it. The woman in the back row shifted in her seat. "When did you become aware of that?" "I'm not certain of the exact date." "Approximately." "Several months before the article, perhaps?" "Several months." "And what was your response to that information at the time?" I wasn't directly involved. That went to HR." "Right. HR handled it. I looked down at my papers. I turned one page. Then I looked back up." "Ms. Hargrove, in your professional experience, advisory or otherwise, when an employee files a formal internal complaint, what is the standard expected response time?" She blinked. I believe the standard is 30 days." 30 days. "And if an employee filed 3 complaints over 14 months with no resolution, that would be a significant failure on HR's part." "A significant failure," I nodded slowly, "but not your concern, since you're advisory." "I didn't say that." "What would you say?" Patrick Holloway cleared his throat. "Your Honor, I'm not sure the internal processes of Hargrove Technologies are directly relevant to the breach of confidentiality question before—" "Mr. Holloway, I did not raise my voice. I didn't need to. I have been listening to arguments about relevance in this courtroom since before your client was born. I'll determine what's relevant. Thank you." He nodded once and was quiet. I turned back to Celeste. "Ms. Hargrove, I'd like to ask you a simple question, and I'd like you to take a moment before you answer it because I want your real answer, not your prepared answer." Something shifted behind her eyes, barely perceptible, but there. "You've testified that Ms. Adeyemi violated her confidentiality agreement by sharing a proprietary document. And the basis of this lawsuit is that the document was confidential, meaning it was not intended for public disclosure. And Ms. Adeyemi had no authorization to share it." "That's correct." "I see. I looked down at my bench. I took my time. Miss Hargrove, if the document was confidential, if its contents were truly internal information not intended for outside eyes, how did it come to appear in your company's own internal complaint log, filed by Mrs. Adeyemi 14 months before she spoke to anyone outside the company? The courtroom was absolutely still. Celeste Hargrove opened her mouth. Nothing came out. Because a confidential document by definition becomes less confidential the moment it is used to file a formal internal complaint, I said, which means Miss Adeyemi wasn't the first person to make this information visible. Your own HR system was 14 months earlier with your company's letterhead on top. I reached to my left and lifted a single sheet of paper. I slid it across the bench toward Patrick Holloway. I didn't say a word. He looked down at it. I watched his face. He looked at it for 11 seconds. I know because I counted. Then he set his pen down on his notepad. He did not pick it up again. The paper sat between us. Celeste looked at it from her seat. She recognized it. Of course she did. You don't launch an $85,000 lawsuit without reviewing the documentation. She had seen this page. She had known it existed. She had brought this case anyway, betting that I wouldn't find it, or that it wouldn't matter, or that the weight of her family's name and her attorney's hourly rate would simply make it irrelevant. She had miscalculated. I have 40 years of people miscalculating in front of me. Mr. Holloway, I said, would you like a recess to consult with your client? He said very quietly, that would be appreciated, Your Honor. I said, you have 10 minutes. The recess lasted 8. When they returned, Patrick Holloway stood and said that his client wished to withdraw the complaint. I said, I understand. I'm going to say a few things before I do that, and I'd appreciate your client's attention. I looked at Celeste Hargrove directly. You came into this courtroom this morning with everything, I said. Resources, representation, a name that opens doors. And you used all of it to try to punish a woman for doing something that your own company's protocols specifically invited her to do. She followed the rules, every single one of them. 14 months of following the rules, and she got fired for it. Celeste was looking at the table. I want you to understand something about what happens in rooms like this. Not conference rooms, not boardrooms. This room, the people who walk in here without attorneys, holding folders they bought at the drugstore, those people are not naive. They are not unsophisticated. They are not confused about how the world works. They understand exactly how the world works. That's why they're here, instead of giving up, because they decided that even if the world is arranged against them, they are going to make it look at them directly for 5 minutes and say what they know. The woman near the back of the gallery nodded once, slowly. Miss Adeyemi lost her career. She lost her professional reputation. She lost 4 years of work at a company that was, by the evidence of its own documents, using her precision and her discretion and her silence to operate a system that cheated 340 of her colleagues out of wages they had earned. I paused. She reported it internally and was ignored. She reported it again and was patronized. She reported it a third time and was let go. And then still, she took one document, 1 page, to one journalist. After 14 months of trying to fix it the right way, I let that land. That is not a breach of confidentiality. That is a person who had exhausted every sanctioned option and chose the only remaining one. There is a legal argument to be made about what she did. Your attorney knows it, and so do I. But you didn't come here to make a legal argument. You came here to make her stop, and that I won't help you with. I signed the dismissal. I slid the paperwork to my clerk. Complaint dismissed. No costs awarded. Miss Adeyemi, I'd like a word with you before you leave. She came to the bench after the gallery had thinned. Up close, she looked more tired than she had from a distance. The kind of tired that has settled in past the muscles, past the point where sleep addresses it. The kind that comes from a long fight carried alone. I said, you did the right thing. I want you to know that someone with more than 40 years of experience in this system looked at what you did and found no fault in it. She said, thank you, Your Honor. She paused. Then she said, I want to ask you something, and I apologize if it's not appropriate. I said, go ahead. If this had gone differently, if she had won, she was choosing her words the way she chose everything, carefully. The 340 employees. The back pay settlement negotiations are still ongoing. If there had been a judgment against me, if I had been found liable, that would have been used in their proceedings against them. I understood what she was asking, whether she had known the stakes when she walked in, whether she had understood she wasn't just carrying her own case. I know, I said. I just want you to know I knew, she said simply. It wasn't just mine. She thanked me again. She picked up her folder. She walked out of my courtroom at 11:43 a.m. 6 months later, a journalist named Thomas Beckett called my chambers. He asked if I had a moment. He told me that 2 weeks after the dismissal, he had received a call from Nneka Adeyemi. He had been preparing a follow-up story, a significant one, with new documentation about the scope of the pay discrepancies and the company's response. It would have been, by his description, difficult reading for everyone involved. She had asked him to wait, not permanently, not to kill the story, to wait until the back pay settlement negotiations had concluded so the 340 employees wouldn't be negotiating against a media cycle. He said, she had no legal obligation to do that. She had every right to let me run it. I want you to know she asked me not to. Did you wait? I asked. I did, he said. The settlement was finalized last month. $4.1 million in back pay, distributed to 340 employees. Average payment of $12,058 per person. Story ran the following week. A brief pause. I thought you might want to know she made that call. I thanked him. I sat with it for a while after I hung up the phone. Here is what I want to tell you. After 40 years, justice is not complicated. Human beings make it complicated because complication benefits the people who can afford complication. Strip it down, get rid of the Latin, the billable hours, the procedural motions, the documents filed in the right format by the right firm on the right letterhead. Strip all of that away, and what remains is simple. Did you do right by the people around you? Nneka Adeyemi sat in that hallway alone with a 40-cent folder and the full weight of what she had lost and what she might still lose. And she had already answered that question for herself long before she walked through my door. She wasn't there to be vindicated. She wasn't there for damages or apologies or a moment of public reckoning. She was there because she had decided somewhere in those 14 months of being ignored and dismissed and eventually discarded that she was not going to sign a piece of paper saying she had been wrong. And she wasn't. I have been asked over many years what I believe this work is for, what a courtroom is actually doing in the world beyond the processing of claims and the management of disputes. I'll tell you what I believe. I believe it is one of the last places where a person with nothing but the truth can stand across from a person with everything but the truth, and the truth still wins. Not always, not automatically, not without cost. Nneka Adeyemi paid a cost I would not have asked her to pay, and she paid it before I ever saw her face. But she walked into my courtroom that morning, and she sat at that table without a lawyer and without a safety net, and she said, I won't sign something that says I was wrong. And she wasn't. That's the whole story. Everything else, the jacket, the black car, the name on the building that's just furniture. The truth is, the only thing in that room that matters. And on that particular Tuesday morning at 8:32 a.m., it was sitting quietly in a manila folder, color-coded, waiting to be heard.